Attorney Laura Anthony, founding partner of Legal and Compliance, a full-service corporate securities and business transactions law firm. Today is the continuation in a LawCast series talking about the recent change to allow all companies to file draft confidential registration statements. The SEC recently expanded the ability to file confidential registration statements for all companies completing an initial public offering or follow-on or secondary offering that is filed within the first 12 months of first becoming publicly reporting, and for Section 12B Exchange Act registration statements. The ability to file confidential draft registration statements was previously limited to emerging growth companies, or EGCs, and companies filing Regulation A+ offering circulars for their first-time Regulation A+ offerings. A registration statement under Section 12B of the Securities Exchange Act is necessary to register a security for listing on a national securities exchange. A Form 10, or, under certain circumstances, a Form 8A, is used to register securities under Section 12B. It should be noted that those are the same forms, Form 10 or Form 8A, that is used to register securities under Section 12G of the Exchange Act. Section 12G registrations are required when companies meet certain shareholder or asset thresholds, but can also be filed voluntarily. As mentioned, the SEC will accept confidential draft registration statements for follow-on offerings that are submitted prior to the end of the 12th month following the effective date of the company's initial Securities Act registration statement or Section 12B Exchange Act registration statement. In this case, the company must file a cover letter confirming that it will file all public registration statements and non-public drafts previously submitted at least 48 hours prior to any requested effective date. In the case of a follow-on registration, the SEC will only allow a confidential submission of the first draft. Any subsequent amendments responding to SEC comments would need to be filed publicly. The company also must file the initial confidential filing publicly when it submits its first public filing of the registration statement. So any prior non-public filing would then need to be made public. In general, the SEC will review draft registration statements and related revisions on a non-public basis, except for follow-on offerings, if the company files a cover letter with the initial draft registration statement confirming that the company will file publicly the registration statement and all non-public draft submissions at least 15 days prior to the anticipated effective date of the registration for its listing on a national exchange. As noted, if it's a follow-on offering, only that first draft can be filed and reviewed confidentially. I'm securities attorney Laura Anthony, founding partner of Legal and Compliance and producer of LawCast. Should you have any questions about today's topic, please visit securitieslawblog.com and lawcast.com or contact me directly. Inquiries of a technical nature are always encouraged.